hour. Joining me now to talk more about this is former federal prosecutor and former Department of Justice Senior Attorney Tammy Allison. Tammy, great to see you again. Thanks for coming on tonight.
Yeah, Michael.
All right, so you heard the testimony there, the final witness by the state. His narrative fits with everyone else's narrative. I mean, maybe even takes it a step further with some of the words that he heard after the shooting. Is there any chance at all that the defense can pull a rabbit out of a hat in this one? Again, it's reasonableness. Even if they buy his statement, the fact that maybe something was thrown at him, do you think they have a chance here?
You know, Michael, there's always a chance because you and I, we always talk about that doubt with that burden of proof in any criminal trial, which is beyond a reasonable doubt. So the defense is going to chip away at anything, even if it's as ridiculous as popcorn being thrown at somebody to justify them shooting someone to death and injuring their wife. Yeah, that's wild and crazy and not normal. But the defense has to do their job so that the defendant has his constitutional rights to effective assistance of counsel protected. So I don't know if their strategy is going to be successful, but I can't knock them for trying, Michael.
Yeah, you cannot. And actually, that leads me to my next question. There's a lot of people online who have taken issue with the aggressive cross-examination by the defense attorneys, saying that they're bullying the witnesses, they're nitpicking on little things about whether a finger was on a temple or closer to an eyelid, things of that nature. But they also, in the same sentence or the next sentence, say, but hey, if I was in trouble, I might call on these guys, because they respect what they're doing. And I think ultimately, what they're doing is, I don't think the facts are in their favor, Tammy, clearly. So they're trying to create as much confusion as possible. But even if this jury buys that there was confusion, it was dark, it was loud, and maybe even the idea that a cell phone was thrown, even again, there's no evidence of that, I don't even know if that's enough. What do you think?
So I don't think that's enough at all. And, you know, people that criticize this creating that doubt, raising the doubt so that the jury might find their client not guilty, you know, perhaps they're not familiar with the criminal justice system, which is why, you know, we do things like this show and break it down and talk to people about it. Anybody who is accused of any type of crime, no matter how obvious it is that he did it, because you and I both know he did this, and like, it's not gonna work. They have a constitutional right to have effective assistance of counsel. And this counsel, these defense attorneys, they're doing a really good job of quote unquote nitpicking. That's what they're supposed to do. They're supposed to preserve the record for appeal just in case he does get found guilty. He won't be able to raise that ineffective assistance of counsel in his appeal. So these defense attorneys are doing what they're supposed to do. They're trying to raise that doubt, which is what anybody that is accused of a crime would want their defense attorneys to do. I really don't think that popcorn being thrown at his face, a cell phone, if that was to happen, as we stated, there's no evidence suggesting that a cell phone was thrown. I don't think that's going to convince the jury of anything. I think the jury most likely will find that the defendant is guilty here.
Yeah, I think that's fair enough. Now, the big question is, and maybe the only chance they might have at this point is, will the defendant take the stand? Now, the jury's already heard from him, Tammy, because he was interviewed by police and that was taped. So they heard him on that tape saying some things that clearly aren't or haven't been supported by the tape or the videotape that they have or the eyewitnesses. Do you think it makes sense for him to take the stand?
You know, Michael, we always talk about the fact that a lot of times defense attorneys do not want their clients to take the stand because once they say one wrong thing, it opens the window to anything that could lead to self-incrimination. But a couple of the trials we've covered this year and last year, we've surprisingly seen some defendants take the stand in their own defense. And in some cases, it worked out for them, and others it didn't. So in this case, given these set of facts, I don't think it's a good idea for this defendant to take the stand because there's nothing to excuse murdering someone over popcorn or a cell phone allegedly probably being thrown at him in the dark.
Yeah, I agree. I mean, his story was already told through the tape, so they've heard that. If he takes the stand, now Tammy, he had other incidents involving movie theaters and having people, arguments with people. So if he takes the stand, he opens up for that to come in as well, and I think that won't bode well. I think they're gonna fly on that tape, but we'll see what happens. Tammy, stand by. We're gonna take a break right now. Coming up next,